see nationwide in terms of the law and some of the news coverage. And so I'm just putting that out there at the beginning. Some of the things we talk about may be more or less comfortable for some people, but we're going to err on the side of providing you the information so that you're informed as you use technology responsibly. This first slide just goes over the disclaimers. It wouldn't be a legal presentation if there wasn't a lot of boring legal disclaimers, so we have to stick this in. This is basically just saying that we represent school districts only. We don't represent parents or students or teachers. So nothing we say today is going to be confidential or create an attorney-client relationship. And that way we can have a kind of a more robust discussion. This is kind of what we're going to cover today. There's consequences if you don't use digital citizenship good practices or technology responsibly. There's school-based consequences. There's criminal prosecution, and then unfortunately, there's victimization by predators. We're going to talk a little bit about each one of those. You'll hear a lot of stuff about cyberbullying, and it is an initiative to stop people from disrespecting or harassing people online. But one thing we want to point out is it's better just to think about bullying, whether it's, I'll call it analog, person to person, or harassment in a classroom or online, right? It doesn't change the rules or how you should treat one another. It's just another way in which people can communicate in a way that's not healthy. So this statute here, this is the discipline statute related to ongoing pattern of physical, verbal, or electronic abuse. It's an activity that's, any other activity that's forbidden by Nebraska law, allows the school to discipline you. Now, what I want to point out here is a lot of times in terms of school discipline, there's a jurisdictional requirement for most of the things that you'll get in trouble for. It has to happen typically on school grounds, in a school vehicle, at a school activity, right? There's a subset of things if it's sexual assault and it occurs off campus, the school might be able to impose discipline for that, but generally it needs to kind of involve something related to the school. Those computers that you get from the school, those one-to-one devices, that's considered school grounds in terms of what you can be in trouble for. So even if you're using that device on a Saturday night at 10 p.m. and has nothing to do with school, and you're doing something that's contrary to the rules that the school is going to give you about how to responsibly use that device, you can be disciplined for it through school, whether that's suspension, expulsion, everything under the Student Discipline Act. That one-to-one device that the school issues, that's considered school grounds. So just be aware of that. The other thing is, it's not just limited to the student that has checked out that device. Anybody using that machine, that student can be in trouble for. So if somebody else in the household is using that device, if somebody outside the whole household but is using that device, that student can get in trouble for it. So as you're using it, make sure you take care of it, make sure you're using it for things that you're supposed to do for your class. As I said, you can lose the district technology, you can lose extracurricular privileges, you can be suspended or expelled. So let's talk first a little bit about things that we see when technology is not used responsibly and how it affects your ability to participate in sports and activities. This is a case out of the Fifth Circuit. This cheerleader posted a pic on Snapchat. It's sent to a group that's called Weekend Schemers. Apparently it maintained as an account that posts pictures of partying and lead the authority on college life and kind of that type of interaction. So many of the photographs from Weekend Schemers were from Snapchat accounts that depicted young women exposing their butts. The school found out about it, and the student was given 3 days of in-school suspension. And she was also kicked off the cheer squad, and she was prevented from trying out for cheerleading her senior year. Parents thought that was overkill and disagreed with the school's position, so they sued. They said the student handbook didn't permit that type of punishment. They said that the First Amendment protected her actions, and that preventing this girl from exposing her buttocks and then barring her from cheerleading the next year was a violation of Title IX. It discriminated against her on the basis of gender. The court ruled against the student, so the family failed to present direct or circumstantial evidence that would give rise to an inference of unlawful discrimination. This is a good quote from the court. The student was not excluded from participating in cheerleading because she was a female student. She was removed from the team because she posed for a photograph raising her cheerleading uniform skirt, and then that photo was posted on the internet, right? So there's lots of things that, an eternity ago when I was in high school, if someone saw you do it, you might be in trouble, but if no one saw it, that, it went away. You're going to see a theme throughout a lot of these problems is that once it's on the internet, it becomes more inflammatory, people publish it more, and it doesn't go away. So obviously, a lot of people are on Twitter now. You want to be careful what you tweet. The things you do in private, if they have a substantial disruption to school, you can get in trouble for them. This was a senior basketball player. She had a 3.5 GPA. She had a high scoring average, 5.5 rebounds per game. The State Athletic Association, where she was competing, had passed a rule that was basically trying to limit negative cheerleading, negative cheers, kind of the rowdy rooters in like basketball, volleyball, things like that. The state said, you know what, you can cheer, but keep it positive, don't be so critical. Well, she had an opinion about that. And so she tweeted it out and told the Athletic Association what she thought about it. She ended up with a 5-game suspension. She said she never thought it would get her in trouble like that, just by putting that tweet in there, right? This is a basketball player. He's a senior basketball player. He has a Division I scholarship. He's a state player of the year. He tweeted at the other team in or around the playoffs. Shout out to Portsmouth. You may have won in the regular season, but we won the ship. You suck. F yourself. He deleted it after 15 minutes. But it had been screenshotted and people sent it around. The State Athletic Association stripped him of the player of the year status just because of this tweet. The soccer player, he retweeted a pro-pot legalization account. He didn't even write it or author it, he just retweeted it. He was removed from the team, sued the school, and lost in that lawsuit. Okay? There is a much lower right, if any, to participate in extracurricular activities. In fact, you don't have a right to do it. So the things that maybe you can't get in trouble for in school, you can get just kicked off the team for stuff that the school doesn't like if it violates the activities code. Okay, so some of these tweets and these things that make the school look bad or that your administrators, your teachers, or patrons find offensive, you can have significant consequences from your extracurricular activities. That's the takeaway. Obviously, it can be more severe as well. Anytime you see these silly cartoons, your gratuitous laughter is appreciated because we're just trying to throw it in there to break up some of the monotony of all this otherwise boring stuff. You want to be careful what you like on social media, okay? This student was suspended for liking a picture of a gun. The caption on it said, "Ready," and he liked it. He hit the little heart. Does anybody notice anything about the gun? Yes? No? Normal gun? It's actually an airsoft gun. It's not even a real gun. Student received a 10-day suspension, and the superintendent quote in this quote, I think, sums up how a lot of administrators feel, especially in kind of today's society of worrying about gun violence and on-campus assault. Says, "The superintendent of Edgewater City Schools, I assure you that any social media threat will be taken seriously, including those who like the post when it potentially endangers the health and safety of students or adversely affects the education process." What I'd say, this isn't a Nebraska superintendent, but what I would say is that people aren't knee-jerk or overreacting, but they're very, very careful. So things like this, even though it's not a like, oftentimes the like is seen as some type of an endorsement or agreement with somebody else's post. This is a case out of the Northern District of California. The student created an Instagram account with limited access, around 10 other kids. The posts were racist and threatening in nature. The Instagram account was closed, okay? So it wasn't like blasting it out to the world like somebody tweeting something. It was just those 10 kids. Surprisingly, it didn't stay to those 10 kids, which is often something you see, so just be aware of that. In the post, it had a KKK starter pack, had a picture of a white man beating a black slave, had pictures of African Americans with nooses drawn on their necks. Pretty offensive stuff, right? So, first 10 students, word gets out, I think it's like on a Saturday night at a party, some African American students get shown the Instagram account, and all of a sudden, the news spreads throughout that community. The Instagram account is deleted. The creator, the school expelled the creator of the account, and then the students who liked and commented on the account were also disciplined. It's a closed group. The court said that liking the post broadcasts the user's expression of agreement, approval, or enjoyment of the post. In the lawsuit, one of the issues was was that protected speech. Was it protected under the First Amendment such that the school was barred from taking disciplinary action against the students for exercising their First Amendment right? The court found that there was a nexus between the Instagram account and the school and the posts about staff, students, and activities. The rule in schools about the First Amendment, it goes back to a case out of Des Moines, actually. It's called the Tinker decision. It was back in the 60s or 70s. Students wore a black armband to protest the Vietnam War. And the takeaway from that was the school can discipline students if it's reasonably foreseeable that the off-campus speech would have a substantial disruption in the school environment. So, if you're doing things off campus that end up causing a disruption at school, even though it's protected by the First Amendment, the school may still have an interest in taking disciplinary action against you. Okay? Just be aware of that. And this is what this court found, is that that closed Instagram account, when it was naming other students and had such inflammatory racist content, would cause a substantial disruption at school. The court upheld the student's discipline. The one thing I want to point out here, it's kind of, I don't know that I would take this away as a rule that's forever, but in that case, there were students that created the account, there were students that posted things, there were students that liked some of the posts, and then there was a student that was a member of the account, and another student that hadn't liked any racist content, and the court treated those students differently. The students that had actively engaged in the offensive content, they basically, their discipline was absolutely upheld. The other students, the court hadn't decided that yet when they published that. So I guess what I'm saying is, the more that you engage in it, the more that you're the speaker, the more that you like stuff, it is seen as endorsing it, then the stronger the disciplinary action is going to be. I think in this case, the kids that were just part of that group are still going to get the discipline, but the court at least treated them differently for that legal opinion. This is a case out of the Eastern District of Pennsylvania. The student made a mashup video and posted it to Instagram. So have you guys seen the Evan video? Has anybody seen that? It was put out by the Sandy Hook Foundation, and it kind of shows the story of a boy and a girl interacting with each other, and the main plot at the beginning is them running into each other, them leaving notes for each other in the library, and then it kind of shows them eventually finding out who each other are, and it looks like they're about to have an interaction, and then out of a door in the gym, someone comes in and basically starts shooting up the school. And then they replay the video and show like the background of all of the first scenes that they were showing you, that it was about a boy and a girl leaving notes for each other, and it was showing somebody researching guns, somebody researching violence, somebody making threats. And so the whole point is to pay attention to everybody and not what's just in front of our face, and have a more safe environment. That's the point of the original video. Well, this kid took the video and then he overlaid the song Pumped Up Kicks. Has anybody heard that song? Like, you better run, you better run, you better outrun my gun, right? And so it basically had an overlay of like a violent threat of shooting on something where they were already talking about gun violence. And he posted it with this post that said, "See you next year if you're alive. See you next year, it's not a threat, you N-words need to chill." So what's crazy about this is it was posted at like, these aren't the exact times, but let's say it's posted at like 7:30 one night. Like within an hour, students and parents see that and get concerned. They start calling people, start calling law enforcement. The Pennsylvania State Police contacted the principal at 2 a.m., finally got a hold of him, and school was canceled the next day. So it was that fast in terms of the threat between the school violence, endorsing it, saying people may not be alive the next year. Like within one evening, school gets canceled. So the student wasn't criminally charged. The school sought to expel the student, and we know about it because the parents sued. They argued that there was no prior disciplinary history. He wasn't a special ed or a Section 504 student. And they claimed that disciplining him based on that post was a free speech violation. Again, what we talked about before, right? It was off-campus speech, posted somewhere else. Presumably it wasn't a school computer, didn't happen on campus, and he gets in trouble for it at school. So that's what the court's deciding here. The court said that the speech did in fact cause a material and substantial disruption to school. School was canceled, right? Instructional time was lost. A lot of students were affected by it, and that the speech reasonably led to forecasted disruption. The kid argued, no, I was trying to make the point of the Evan video that much more effective. I was adding that song to make it seem like a bigger deal. Whether that was true or not, you never know, but that was his argument. I was trying to make it have a bigger impact. The court said, we don't care. Although the student argued that the post was meant to be a joke, the student's subjective intent was not relevant to the court's application of Tinker. Tinker standard also did not require the court to decide whether school officials' characterization of the student's speech as a threat was proper. Okay, so there's two things in here. One, what you meant by it doesn't matter. Doesn't matter at all. Whether you were totally wholesome telling the truth and it was a joke, or whether you had bad intents and now you're trying to cover your tracks, it doesn't matter what you meant by the post. What matters is the effect it has on the school environment for the court. And then the second thing is, and this is true in most of the First Amendment law as it relates to schools, is that the courts are going to give deference to the school administrators and the school leaders. So if the school determines it's a threat to school, it's going to disrupt, right? It doesn't mean they win all the time, because if they're wrong or they had a bad faith basis, they're not going to win all the time. But the point is that if you do things that the administration determines is going to be substantial